Counsel, you make an argument that Hawaii effectively destroys the right to bear arms. You discussed that a little bit with Justice Thomas and with Justice Sotomayor, and I'm wondering where you think that analysis fits into the two-step Bruin framework the court announced.
In this case, step one merely deals with the fact that the state of Hawaii, that Kerry is implicated here. And once we go once we accept that Kerry is bearing an arm is at issue here, everything else is dealt with under step two, the historical analysis portion of this analysis, Your Honor.
So it really doesn't matter whether it was actually 96%, which we know it's not, because you're dealing with the law as a whole. There's no means-end scrutiny permitted by Bruin, correct?
Interest balancing has been abrogated by yes.
By Bruin.
Yes,
so there's no interest bearing. So if, in fact, if Hawaii has a right to regulate a custom as opposed to a constitutional right to bear an arm on private property, then tough luck, correct?
We have established in our briefing, Your Honor.
Counsel, there's no means ends. So if they overregulate or underregulate, that's irrelevant. Is there a right to carry a gun?
As we know from Rahimi, there's a general principle that dictates that you have a general right to carry. And when the government violates that rights, then because it violates that principle, then the second...
That's the interesting part. There certainly was a principle of the states regulating hunting on private enclosed property. There was a history of, in at least New York, in 1763, just before the founding, that prohibited trespassing and hunting on other people's lands because trampling on the land was destroying it. So you don't need, under Rahimi, an exact duplicate historically. You just need an analogous principle. If the states could regulate there, why can't they regulate here?
Well, very simply, those laws deal with are not anywhere close to the law at issue here. The state has pointed to a number of anti-poaching laws on property that was not open to the public, whereas here they're regulating a specific type of carry for self-defense on private property open to the public. I mean, these laws are just simply not...
But what's open to the public and the license that you have to use that land is subject to custom.
It's subject to a national tradition that we had at the time of the founding, Your Honor. It's not, a specific custom that exists right now.
If means and ends is not a part of our equation, I don't understand what pertinence that has.
Because in order to do the Bruin analysis, we look to see whether a law is implicated by the Second Amendment right. Then we look to see what the historical tradition was in this country.
But that
Counsel?
seems... I'm sorry. If you could regulate to not trespass, trample the ground, if you could regulate not to hunt, if it's not means and ends, why can't you regulate simply to switch a presumption that gives the owner the right it has to give you express consent to say yay or nay to carrying the gun?
Well, for two reasons, because that violates our nation's historical tradition of firearms carry, and two, it violates a principle that...
But we didn't have...
Counsel, I see that